Hi guys, welcome to official_Joel TV. Today we'll be running through NOLLE PROSEQUI and its side effect on the judicial system. NOLLE PROSEQUI is a constitutional power vested in the Attorney General of a federation or the state. Now, who is the Attorney General? The Attorney General is the chief legal principal officer of a state or the federation. Section 174 and 211, subsection 1, paragraph A to C provides for the office and functions of the Attorney General of the state and of the federation respectively. Subsection 1 provides the Attorney General of the federal or state level respectively shall have the power to A. institute and undertake a criminal proceeding against any person before any court of law in Nigeria other than a court martial in respect of any offence created by or under any act of the National Assembly. Paragraph B. To take over and continue any such criminal proceeding that may have been instituted by any other authority or person. And paragraph C. To discontinue at any stage before the judgment is being delivered at any such criminal proceeding instituted or undertaken by him or any other authorities or persons. In view of the above provisions, it is clear that the Attorney General has the right to discontinue at any stage before judgment any criminal proceeding. This is what is generally referred to as the power of NOLLE PROSEQUI. The Attorney General can issue a NOLLE PROSEQUI with respect to a case with which he wishes or deems fit to discontinue. This function is either carried out by the Attorney General himself after informing the court of his intention to discontinue the proceeding, or by an officer in his department or any other private person as provided by section 174 subsection 2 and 211 subsection 2 respectively. But such person must be armed with a written authority or fiat of the Attorney General. In Nigeria, the office of the Attorney General is always combined with the Minister of Justice at the federal level and Commissioner of Justice at the state level. This automatically makes the Attorney General, be it of the federal level or the state level, a member of the executive. In view of the above, it is my crucial submission that the power of the Attorney General is too wide and absolute, thereby making it a tool for manipulation of justice, as this is very harmful and dangerous for the administration of criminal justice in Nigeria. Let's see some instances at which this might be true. Since the Attorney General is a member of the Executive Council, he is automatically subjected to the control of the executive arm of government. In other words, it will be very impossible for the Attorney General to go against the will of his appointers meaning the executive, in matters that his appointers has interest. Secondly, criminal cases involving members of the ruling parties, especially the executives, may be compromised by the Attorney General, who is a dual member, by invoking his constitutional power of NOLLE PROSEQUI, thereby mismatching and truncating the course of justice. This is heavily possible since the exercise of this power of the Attorney General cannot be challenged or reviewed by the court or by any other authority. And lastly, the power of the Attorney General may be selfishly invoked by the executive council to silence the opposition to silence the opposition of the ruling party, or by bringing unnecessary and needless criminal charges against the opposition just to cow and disgrace them out of the political race. However, for a NOLLE PROSEQUI to be valid, it must have been invoked where the matter or the case is threatening the public peace and also national security. So the remedy for this is that where there has been an arbitrary use of the power of NOLLE PROSEQUI, it is the affected party that is going to bring a case against the Attorney General himself and not the state. It is going to be, for instance, if I'm the aggrieved, it is going to be Adeleke versus the Attorney General of the state. Thereby, I can sue on the grounds of arbitrary use of the power of NOLLE PROSEQUI. Conclusively, for the sake of peace and transparency in the Nigerian democracy, I suggest that the provision of the section 174 and 211 of the Constitution of the Federal Republic of Nigeria 1999 as amended be re-amended, so as to authorize the court to review the exercise of the power of the Attorney General where necessary, and also to separate him from his dual functions so as to strengthen the age-long principle of separation of power and independence in the Nigerian justice system. This is official_Joel TV. Stay tuned for more videos like this. Like and follow for more.